Members, it's the appointed time. We have a quorum. I call the meeting to order. This is the Bills Committee on Gas Safety Amendment Bill 2025. This is the fourth meeting. Item number 1. We will first invite the administration to come in to join us. In relation to the submission by the Chinese Dream think tank, the administration has given a reply. Is uploaded onto the Ecology website. Please refer to CB bracket 21128 of 2025 bracket 01.
好，大家早晨。
Good morning. There was a discussion in the last meeting. There is a list of follow-up actions. Please refer to paper CB bracket 21188 of 2025 bracket 01. I now invite Mr. Cheng Chin King, Chief Engineer of the Gas Standards B of the EMSD, to take us through the reply. That is paper CB bracket 21188 of 2025 bracket 02. Members, if you have any questions to ask, please press the request to speak button. The floor is yours, Mr. Zhang. Thank you. In relation to the meeting on the 2nd of June, members had a discussion. We've received a list of follow-up actions. And this is our written reply. I'll read it out. First, in relation to the proposed new definition of regulated hydrogen, the question was whether a footnote will be added to the revised proposed new definition to specify the international standard on which the definition is based. This is our reply. In proposing the new definition of regulated hydrogen, the government has made reference to the international standard ISO 14687 of 2025. The government has also taken into account other applicable standards and the actual situation in Hong Kong. We would like to, we think that in order to avoid a misunderstanding and to maintain flexibility, we consider that a footnote will not be added. The second question is in relation to the proposed revision definition of a service riser. There is this formulation other than regulated hydrogen to more than one floor of a building. Members asked whether it covers a surface pipe used or capable of being used to supply gas to half a floor, for example, a garret of a building. We have spoken to the Department of Justice. The definition of service riser already covers surface pipe used or is capable of being used to supply gas to a garret of a building. In the proposed amendment, we will repeal 超過樓層的一層 more than one floor of the building and substitute it with 超過一個樓層 more than one floor. We have amended the Chinese wording. We have kept the original meaning of the definition. The third question is the proposed new definition of 指明實體 specified entity. We were asked to explain that in the Chinese text, when it refers to 該車輛的 of the vehicle and specified owner under cap 374 of the Road Traffic Ordinance 道路交通條例第734章所指的擁有. In the English text, there is only one condition, but there are two conditions in the Chinese text. We were asked why. Also, we were asked whether in the Chinese text would narrow the scope of the new definition. This is our reply. Paragraph A of the proposed new definition is in relation to a hydrogen system. If the system is installed in a vehicle, the owner of the vehicle is a specified entity. The meaning of owner has incorporated the definition of owner in the Road Traffic Ordinance, Cap 374. In the English text, the owner within the meaning of the Road Traffic Ordinance, Cap 374, corresponds to the Chinese text of owner, 擁有人, of the vehicle corresponds to 該車輛的 of the vehicle. So both Chinese and English texts carry the same meaning. The reference to 該車輛 of the vehicle does not narrow the scope of the new definition. Another question under this is the use of the term 擁有人 owner. At the same time, in relation to Section 2, the definition of owner, the Chinese is different, 车主, owner of the vehicle. How come there are two different terms referring to owner? One is owner, the other one is owner of a vehicle. This is our reply. Under Road Traffic Ordinance Cap 374, both 擁有人 and 車主, owner and owner of a vehicle, corresponds to the term owner. There is no difference in semantics. In the bill, the new definition specified entity refers to a hydrogen system. The systems refer to the propulsion of a vehicle or a train, or a system that is intended or used in the operation of a specified machinery. The definition of 車主, owner of a vehicle, refers to the owner of a gas vehicle or a hydrogen conveyance vehicle, that is, say for example, a tube trailer that uses diesel as fuel for propulsion and conveys hydrogen. The owner is 車主, the owner of a vehicle. When it comes to 擁有人, owner, it refers to the owner of a vehicle or a train, say for example one that is a bus of the city bus. That's why we used two different terms in Chinese to make the meaning clearer. If you refer to machinery, the Chinese term 車主 of an owner of a vehicle does not apply. That's why we've used the term 擁有人 owner. The next question is in relation to the alternation in the English text in the proposed amendment in relation to improvement notices. We think that in the English text, alternations should be repealed and substituted by alterations. We will move an amendment in the committee stage. This is our reply. Thank you, Mr. Zhang. Well, now we will allow members to ask questions. I'll read out the names. We have Mr. Chen Xiu-hong. Only one at the moment. 5 minutes, question and answers included. Mr. Chen. I thank the administration for their reply. They are replies to questions raised in the last meeting. I'd like to ask about bracket A, that is the proposed new definition of regulated hydrogen. I would like to seek clarification. Regulated hydrogen. I'm not bogged down by the new definition. However, the revised CAF 51, what does it refer to? Regulated hydrogen refers to gas that is used as a fuel, and if the gas content have 50% or more as hydrogen, the rest being non-fuel gas that is uninflammable, then that is regulated hydrogen. What is the actual definition? In the reply on this occasion and on the last occasion, you have emphasized that you have referred to ISO 14687 of 2025. Yes, it's right for you to refer to this standard, but this particular standard refers to residential, commercial vehicle, as well as the lowest standard. That means if you use hydrogen or the relevant gas as fuel, then you will refer to this standard for testing. When we make the law, we have to be forward-looking. We will consider whether this is a piece of legislation that is of a narrow scope or is general. Well, under this, if there are natural gas and town gas. For town gas, well, about 84 to 51% of it is hydrogen. That means there is an occasion when it contains over 50% of hydrogen. The remaining content will be inflammable. Under this scenario, this particular piece of legislation will not apply, but we already have another legislation. But what about when there is a gas containing over 50% of hydrogen with some content being an inflammable gas? I thank the administration for staying in communication with us outside the meeting. But it says that, well, if there is over 50% of hydrogen and the remaining content is non-inflammable, then it's not covered. But what if there is a scenario in which over 50% is hydrogen and the remaining content contains some inflammable gas? Then this will not be regulated under this piece of legislation, but it will fall under the scope of dangerous gas. Dangerous goods ordinance. You have to make sure that both pieces of legislation will cover all the different combinations of gas. Otherwise, there will be some gas with a combination that is not covered by either. So there is no one that where they will go, nowhere that they can go to get testing. You have to make sure that the legislation will cover new forms of gas. Can I get a confirmation of what I said? Well, when I read the Dangerous Goods Ordinance, I found that there are discrepancies between the Chinese and English texts. That is rather interesting.
Thank you, Mr. Chan Siu-hong. Yes, please reply to Mr. Chan Siu-hong's question for records purpose. Thank you, Mr. Chan Siu-hong. Your understanding is correct. Under the new definition of regulated hydrogen, for gas that is not covered by this term, they would be regulated by the Dangerous Gas Ordinance or Dangerous Goods Ordinance. So they will all be in scope. Now, the new definition is in accordance with the ISO 14687/2025. More than 90% of the gas must be hydrogen. For gases not covered by CAP 51, they would be regulated by Dangerous Goods Ordinance. So when these gases are being tested, there may be new requirements for these tests because of the new market trend and the technology advancement. Now, if the FSD is not sure about the gas, the EMSD will conduct the test first. Thank you. Have your question been answered? Next, Mr. Lai Tong Kwok. My question is on point or paragraph 5 and 6 of the reply. The administration explained that the English term owner, in the context of specified entity, there are two types of articles we are talking about. One refers to owner of a vehicle, one refers to the owner of a specific machinery. But there is still one point that is unclear. Under the existing CAP 51, Section 2, the definition for owner, in the Chinese text there is a bracket, 车主, owner of a vehicle. But in Chinese, the term owner does not exist. So it may give rise to confusion. If we refer to CAP 374, paragraph Section 2, the definition, it says owner in English, and then in Chinese, there are two definitions. One is 拥有人 owner, the other is 车主 owner of a vehicle. Under CAP 51, in the definition, there is only one Chinese definition, that is 车主 owner of a vehicle. Under the new provision, however, you are adding the term 拥有人 to fit the context. So I invite the government to consider, under CAP 51, Section 2, paragraph 2, the Chinese definition of owner, 车主, 拥有人 should also be added to the Chinese definition so that it will be much clearer. Thank you, Mr. Lai Tong Kwok. Administration. Thank you, Mr. Lai. From the perspective of law drafting, one English term would have its equivalence in one Chinese term. So under CAP 51, the Chinese version is 车主, English is owner. It seems that it is sufficient for the context of CAP 51. Now for CAP 374, the definitions for owner and owner of a vehicle are different. So it seems that the existing drafting approach is appropriate. Any follow-up question? Chairman, if you refer to the definition, it says owner means owners refers to the definition of owner under CAP 374 Road Traffic Ordinance. So you are drawing a reference to the other ordinance. So you can't say the definitions are different. And also, in the context of CAP 51, For owner, you mean owner of a piece of machinery. Now, but in paragraph 2, that owner refers to the owner of a vehicle. So one English term has two different translations in Chinese. So in Cap 374, there is only one Chinese equivalent to the English term owner. So under Cap 51, the translation of owner is 车主. That is correct. And you said that if we are adding the Chinese term 拥有人 to the term as well, it is not the usual practice. I agree, but I think you can sort this out. Because under Cap 374, the English term also has two Chinese meanings. So I think there is a way to navigate through this. Thank you, Mr. Lai. We will consider Mr. Lai's suggestion after the meeting. Mr. Lai Tung Kwok, any more follow-up questions? No, thank you. Next, Ms. Doreen Kong. Chairman, allow me to jump into the fray. Now, Cap 374, the English term owner has two Chinese meanings, 拥有人 and 车主, because in the context of road traffic ordinance, owner refers to owner of a vehicle and a private road. So if you refer to the definition of owner in Cap 374, it says a private owner in relation to a private road. And B, a vehicle. That's because the ordinance seeks to cover two types of owners, owner of a private road and owner of a vehicle. That's why there are two Chinese translations for owner. So I think Mr. Lai Tung Kwok has asked a very relevant question. We want to be as clear as possible. So can the administration specify clearly, in the context of 车主, owner of a vehicle? You can just copy the definition from Cap 374, and that would eliminate the discrepancies. Thank you, Chairman. Administration, EMSD or the DOJ? Thank you, Ms. Kong, for explaining why there are two Chinese translations for the English term owner in Cap 374. That's exactly the policy intent. Now for Cap 51, the definition of 车主, owner of a vehicle. We said it refers to the definition under Cap 374 road traffic ordinance because we want to refer to the definition under Cap 374. So Ms. Doreen Kong suggested copying the entire paragraph B under the definition of owner in Cap 374. We will consider this suggestion and whether that is suitable. But I believe our understandings are the same. It's just a matter of expression. Thank you, Ms. Kong. Any more follow-up questions, Ms. Kong? There being no other questions, I have one question for the administration. Having read the reply, I have the same question with Mr. Lai Tung Kwok and Ms. Doreen Kong. We know it is quite rare in our law that we have one English term and with two Chinese equivalents. That exists under Cap 374. But I think if the English term has two different meanings, I think the priority should be given to clarity. So, like my colleagues, I would like to urge the DOJ to consider how to express the term more clearly. I share the same views with my two colleagues. So will the DOJ please consider our suggestion? We don't have to be rigid about the form. So any more questions about the government's response? If there is none, then according to the progress last time, we will resume from clause 7. Any more questions about clause 6, which we have scrutinized last time? Then let's go back to clause 7 of the bill. Please refer to page 21 of the Chinese marked up copy and page 22 of the English marked up copy. Mr. Chang Chin King, please. Thank you, Chairman. Let's resume scrutinizing clause 7, which amends section 14, obtaining of information by the authority. The word he is repealed to be substituted with the authority. English text, page 22. Section 14. The word his is replaced with the authorities. Both amendments were suggested by the DOJ to use gender-neutral terms. Page 21 of the Chinese marked copy, still in section 14, deleting all the words after 執行, to be replaced with the authority may serve the authority may serve on A registered person, B, an owner of a gas installation referred to in section 828(4), C, an owner of a gas vehicle, D, an owner of hydrogen installation, E, a specified entity of a hydrogen system, or F, an owner of a hydrogen conveyance vehicle, a notice requiring such person, owner, or entity to furnish to the authority such information about such matters as are specified in the notice, and to do so in such form and manner and within such period as are specified in the notice. This will empower the authority to require from an owner of a gas installation, an owner of a gas vehicle, or an owner of a hydrogen installation certain information. Now that's the owner of a hydrogen installation rather than a hydrogen system. Yes, thank you. Mr. Ring Kong. I have a question in relation to the drafting of the provision. English, section 14, you want to avoid gender-specific terms. Are you trying to eliminate all he and she's in the ordinance? Or are you referring to the entire ordinance? Please switch on the DOJ colleague's mic. Thank you, Ms. Kong, for your question. Section 14, in English, it says he needs for the exercise of his functions. We want to eliminate the gender-specific terms. So we are proposing to change them to the authority and the authorities. I don't think that's thorough. On page 17 of the English markup copy, section 12E, there are also he and his. 12E, page 17 of the English markup copy, when it refers to authorized officer. 12(1)E, there are many he and hims. Why are you not changing them? Again, page 17 of the English markup copy, section 12(1)E. Thank you, Mr. Ring Kong, for your reminder.
Yes, there is the term he in English version under section 12. When it comes to a bill, we take into account the quantity of gender-specific terms. But this ordinance has a long history. Very often we find terms that are gender-specific. We may not remove all these terms because there are other factors at play. If we are to have a wholesale modification, it will take a long time. In general, what we consider is we will focus on the provisions under the amendment. If there are gender-specific terms, we will use the opportunity to remove them. May I add, I don't agree with that. There are changes in Section 12. I have glanced through the ordinance. There aren't many other gender-specific terms. Cap 51 is not bulky. Why not simply change it all? My suggestion is for you to change Section 12(1)(e). We will look into it. We'll look into the word he under 12, Section 12. Ms. Kong, what are the other provisions that are under the amendment but with gender-specific terms? There is also one second line, Section 12(1)(b). There's also one in Section 12, bracket 2, subsection 2. Under Section 12, subsection 4, any of his powers, he thinks fit. Should we not change them all? You've explained about why you did not change it all, but in relation to this specific section, are there any specific factors that are at play? I have to go back to look into it. In general, that's our approach. If there are many amendments in the bill, then we will take the opportunity to remove them all. But if it involves minor changes only, then we will do it on a case-by-case basis. Section 12, subsection 1, there are changes in D and F. It's not one that is untouched anyway. Any other questions from members? No? Please continue. Page 22 of the Chinese version. In relation to the appeal board panel under 17(1)(e), after E we add EA, not less than 3 persons who represent the interests of persons who are as a business import, manufacture, or supply regulated hydrogen. In relation to, we want to include persons, interests of persons who as a business import, manufacture, or supply hydrogen, regulate hydrogen, to align it with the approach in relation to other gases such as town gas. The next change is to replace 8 bracket 2 bracket A bracket 3 by 8 bracket 2 bracket A bracket 3 bracket capital A. We also, in F, delete F. Under G, we will remove 8 bracket 2 bracket A bracket 3 and replace it. Also, in the Chinese version, we have changed a punctuation under 1G. We add H after G in relation to not less than 3 persons who represent the interests of persons who as a business carry out work referred to in section 82A3B. We want to include interests of persons in relation to vehicle businesses into the appeal board panel. Mr. Tony Tang. I want to get more information. I see that there are references in relation to public officers being appointed as a member. Is it the case that this is the only restrictions? No restrictions in terms of nationality or anything else? I don't think there are any other restrictions. Please continue. Page 23 in the Chinese version. We use a different Chinese word with to replace a Chinese word. They mean the same thing. We use a Chinese word that is written differently. Under B, manufacture, there is also the same change in terms of the Chinese word. I don't think there are any problems to replace one Chinese word with another. But why? What are your considerations? They mean the same thing, but they're written differently. Let me give you some background information. Under Cap 51, we use a Chinese word that is written differently. This is a different form of the word we propose to use. The official word, or the one that is used mainly, is the one that we propose to use. This is our approach, to use the one that is widely used instead of a variation. When you search with e-legislation, you have to use the main form of the word to search. If you use a variation of that word, you will not be able to find what you're looking for. Then it's very clear. Perhaps, well, in your search engine under e-legislation, program it in a way that variations of the word you're searching for will also appear. This will make things easier. If there are no other questions, please continue. Page 24 of the Chinese version. Paragraph G is also a replacement of the main word, using the main word on the variation. Next, page 25 is 82G. Well, we have already removed this section, so there is no need to have any amendments. Now, page 26, 4B of the Chinese version is the same change, to replace the variation of the Chinese word. In relation to Division 2, relevant technical amendment, there are 4 subdivisions. They refer to various regulations and the energy label ordinance. So from 27 to 38, they are the provisions in the regulations and an ordinance, just a replacement of the main word, replacement of the variation with the main word. So from page 27 all the way to 38, that's just to replace a variation of the Chinese word. I have a question for the DOJ. You've make an effort to replace the variation of the Chinese word. You've checked the entire ordinance that you haven't missed any, right? Under 51 as well as its subsidiary legislation, we have identified all the places with the variation and proposed to replace them all. Any questions? No. Mr. Zheng, please continue. Page 38 is also a replacement of the variation, so we move on to page 39. This is part 3. To amend Dangerous Goods Ordinance Cap 295, Section 6 of Part 3, license required for manufacture, etc. of dangerous goods. Subsection 2. We've deleted a large chunk of words after Section 5 in the Chinese version. It will be replaced with words to the effect that in relation to the regulations relating to licenses, and they do not refer to the dangerous goods, gas under dangerous goods. There is a question. Mr. Andrew Lam. I see that you have removed the word petroleum gas. That is the essence of the amendment. When I compare the wording, it says that well, under the regulations under the ordinance, unless it is specified in the scope, it doesn't apply. That is the words to that effect in relation to the Chinese version. And you have replaced it with something that doesn't sound very Chinese. I want to ask, any difference in substance? Not the wording, but the substance itself. Any difference? Who is to take this question? I thank member for the question. Well, it means the same thing, even though the words are different. In relation to the gas, under regulation is not regulated under Cap 295. I don't have a strong view, but to me, the original provision is rather clear. You've now replaced it with something that is not as clear, but it means the same thing. Why don't you simply remove the word petroleum gas? Liquefied petroleum. In the Chinese text, there is a deletion of several lines. In the English version, it's just the replacement of liquefied petroleum gas with gases. Member thinks that the change is unclear. We will look into it. To us, that change in the Chinese version is an improvement.
Any follow-up question? No, from the point of view of a Chinese reader, I think it is worse than before, but maybe from a legal perspective, it is better. I'm just saying that from a layman's point of view, the perspective is different. So I think that the contents of the provision is clear, but please reconsider how we can make the Chinese version more easily understandable. I think Mr. Rock Chen is a Chinese expert. Mr. Chen Xiuhong. Chairman, I'm not as good as Mr. Rock Chen in terms of Chinese, but I have my own doubts. Now, the English text is clear, but that's not the case for the Chinese text. Were there any past issues that caused you to think that the Chinese text is unclear and has to be radically changed? Now, the principle we embrace should be making change only when it is necessary. So was there any past incidents where there were misunderstandings when you are interacting with the trade or the public? That's why you think you need to change it. Otherwise, we can just change the Chinese text like the English one. Simply replace liquefied petroleum gas with gases. In the context of regulated gas, we need to avoid any potential loophole where some gases fall out of the regulatory scope. Now, this time we are adding the gas hydrogen, so regulated hydrogen has a narrower definition. So anything which is not covered by Cap 51 would not regulated by Section 5 would be regulated under Cap 51. So I don't see why this change is necessary. I agree that the original Chinese version was clumsy, but after the change, even Mr. Rock Chen, a Chinese expert, cannot understand what it says. So if this is not so big an issue, just don't change it. If you think it is better after the amendments, please justify the change. How does it make the provision more easily understandable? Now it seems like we are playing with words here. I just want to understand the administration's logic more. Now it seems that members who are good at Chinese and very good at Chinese both have questions. Thank you, Mr. Chen, for your questions. Now, the first question was whether there were past incidences of misunderstanding. Actually, the entire industry understands clearly what gases are regulated by the FSD and what gases are regulated by the EMSD. In terms of the Chinese wordings, may I defer to my colleagues? Ms. Carmen Chan. Thank you, member. In English, subsection 2, it says, shall not apply to or in relation to, sorry, I will start from the beginning. Regulations made under section 5, which relates to licenses, shall not apply to or in relation to any dangerous goods. So the Chinese improvement is that it now reads 不適用於屬第51章所指嘅氣體. That means shall not apply to. For in relation to, it is 亦不就該等危險品而適用. So we want to take this opportunity to make the expression clearer. Chair, I understand that both versions basically mean the same thing. It's just where the translation of shall not apply to is placed. It seems that you are now modifying the Chinese to follow the word order in English. Now, from my humble understanding, in legal drafting, the Chinese text does not have to follow the English text in terms of word order. The meaning is just that under certain circumstances, the law or Section 5 does not apply. But I will not labor on this point. If the administration thinks that's the improved version would be more easily understandable, then keep it. But if you think that we can keep the original version and still make it clear, that also works. Thank you, Mr. Chan Siu-hung. Any supplements from Ms. Carmen Chan? Not for the time being, but as mentioned by members, this amendment is not substantive except for the gas part. I also urge the administration to consider this suggestion. Now, according to Professor Lam Yutong, simple Chinese is good Chinese. Mr. Ring Kong. Chairman, sorry, I am a bit late here. So there were many changes about the Chinese the archaic form of the Chinese character to the official version. I think you have missed out 3 places. Page 2 of the Chinese markup copy. Part B, production. You haven't changed that character. It's the same character. Manufacture. Definition for manufacture, Part B. And page 3, notifiable gas installation, G. There is also one such character there. Page 15, Section 4B. I can find at least 3 instances there with the same character. So please check it again. So do you mean at page 2? Definition for manufacture, Part B. And also notifiable gas installation, Part G of the definition. And page 15, Section 4B. There is also the same character. Thank you, Mr. Ring Kong. Why weren't these characters changed? Thank you. Starting from page 23 of the markup copy, please turn to page 23 of the Chinese version. From 23 to 30 or 26. We have gone back to those characters in the definition. We have replaced those characters here. So the changes referred to on page 23 is actually referred to page 2 mentioned by Mr. Ring Kong. Any more questions, Mr. Ring Kong? So you are making the amendments in the subsequent parts rather than right from the beginning. That's curious, but anyway. Next, Mr. Andrew Lam. Chairman, I'm also following up on my previous question, just very briefly. As mentioned by Mr. Lui, the trade understands the requirements clearly. But if that's the case, if you are making such a radical change, it may cause confusion and cause the trade to rethink the understanding. Yes, the administration is urged to avoid making unnecessary changes so that the trade is confused. So please consider Mr. Andrew Lam's suggestion. So after several meetings, we have finally completed the clause-by-clause scrutiny of the bill. Now here I would like to ask our DOJ, do you have any views on the drafting of the Chinese and English versions of the bill? Thank you. Besides considering members' suggestions raised during the meeting, for example, the definition for owner, and also the gender-neutral term under Cap 51. Last time we mentioned that there would be a change there would be a CSA to section 6, brackets 13 of the English version. And besides these, the Chinese and English texts are consistent. Thank you, legal advisor. Now again, any more questions or views from members? If not, I remind members and also the administration concerning the amendments to the bill. The deadline for proposing amendments is the 20th of June before 5 p.m. That's a Friday. That's Friday next week. Please send the draft of your proposed amendments to the secretariats by that time. Now, members, concerning the written reply from the administration and also the proposed amendments, the papers will be circulated among members, and subject to your views, we may or may not convene another meeting to discuss the papers. After this meeting, I will discuss with the administration and the secretariats concerning the time, the dates of resumption of second reading debate, and also the legislative timetable. Any views about that? There being none, I thank members and the administration for your hard work. There is no AOP. The meeting is adjourned. Thank you.